Well, good morning to everyone. At today's public hearing of the Vetting Commission established under law number 65/2023 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I am Marcel van der Wetering, the Vice Chairperson of the Commission and Chair of Panel D, and I declare this session open. This hearing is being conducted under law number 252/2023 on the external evaluation of judges and prosecutors and amending some normative acts and under the Commission rules of organization and functioning as part of the evaluation process. The subject of today's hearing is Corneliu Guzun, Judge and former Vice President of the Chișinău Court. On 19 September, Judge Guzun was assigned as a Vice President of the Chișinău Court. Judge Guzun, welcome.
Good morning.
Mr. Guzun, I'm joined by two other panel members. To my right is Mr. Lilian Enshu, and to my left is Mr. Yuri Gatkan. And the panel is also assisted by members of its secretariat, and behind you are representatives of the media and the public. Also present today is a photographer who will be taking photographs at the opening of this hearing for a maximum of 3 minutes. As you know, the hearing will be conducted with the interpretation between Romanian and English. And to allow for accurate interpretation, I ask everyone to speak clearly and slowly. And furthermore, proceedings are being recorded. And the recordings of the Commission's public hearings generally will be available online at the Commission's website, www.vettingmd.eu, within 3 days after the hearing. I will start briefly by reviewing the evaluation process for you, Mr. Guzun, as from 2 February 2026. So I won't reiterate everything what happened before. That's what I told at the last hearing. Well, on 2 February 2026, as scheduled, your hearing and the hearing of your witnesses took place. And in accordance with the notification, the initial hearing addressed issues related to potential inexplicable wealth and possible conflicts of interest in connection with your former employer. And following your hearing and the hearing of your witnesses, the Commission was informed of new circumstances that were previously unknown. And this information was provided mainly by third parties and includes circumstances presented by your mother-in-law during a closed session, as well as 2 petitions received from different citizens. So several requests for information and confirmation of these new circumstances were sent to various institutions. In addition, you were addressed a request for clarification, the 5th round of questions, to which you responded, also providing certain data that had not previously known to the Commission. And on 16 March 2026, we notified you that the Commission had identified and wishes to discuss some areas of doubt about your compliance with the ethical and financial criteria, and also invited you to attend an additional public hearing. Specifically, you were notified about the possible difference of approximately 928,000 lei between the income and the expenses, and the possible violation of the conflict of interest regime and ethical breaches. On 18 March 2026, you sent your response confirming your participation to this additional public hearing. And on 27 March 2026, so last Friday, you sent your reaction to the notice of a hearing of 16 March, including 2 statements of third parties and a photo. And this morning, you sent us an email with an annex as well, which we just received and have read. Mr. Guzun, do you wish to make any corrections or additions to the answer you have provided to the Commission's requests and information?
I apologize. Regarding the entire notice or only in relation to what you have said now? I mean, I have nothing to add now. Everything that is in the explanation that I submitted.
So also all your answers provided to the Commission in the 5-year declaration and ethics questionnaire that you returned in May 2025 are still accurate as of today?
Exactly.
Okay. Well, Judge Guzun, I and members of the panel will now ask you additional questions. And we will try to keep our questions short and to the point, and we ask you to be short and to the point as well. Regarding the questions, the first set of questions is about the vacations. During the fifth round, you provided information regarding reservations made for the Booking.com platform, as well as certain expenses related to these vacations. And in addition, you attached your response statements from friends and relatives, according to which they allegedly covered part or all of the costs of these trips. And in order to clarify these aspects, you are requested to answer the following questions. And we start with the private visit to Bucharest, lasting 3 days in 2024. And that's trip number 2 in 2024 in your annex. And you declared there only expenses of 300 lei for RCA insurance, while indicating that all other possible expenses, including those for food, accommodation and other necessities, were covered by your relatives. And in this context, we would like you to describe which activities were carried out during these 3 days in Bucharest.
Yes, that was a visit to relatives, to my sister, and expenses in the amount mentioned in the answers. I answered with that amount because based on the information that was provided to the Commission, I was not alone during that visit. I was with my parents, that was mentioned. And in that situation, the expenses related to transportation, green card, were covered by my family members, and accommodation and other expenses were covered by my sister.
So it was a family visit.
If I'm not mistaken, according to the information, yes, so. To Bucharest. My sister lives there.
Okay. Then regarding to your trip to Germany in June 2024, that's trip number 6 in your annex in 2024, you declared that for a period of 3 days you incurred consumption expenses amounting to 2,000 lei. Can you specify whether you incurred accommodation expenses, and if so, can you indicate the amount? And if the costs were covered by third party, can you identify that person and explain why, unlike in other similar situations, no supporting statement was submitted in this regard?
Talking about that trip to Germany, that was a trip to a sports event. I am not sure that it was 2,000 lei. I don't see the information in the answers. But then I mentioned to the Commission that the expenses were covered by my wedding godfather, and I explained that.
Let's see. I have the annex here.
If that is about the sports event, if it was a football game event in Germany.
It said accommodation expenses covered by my own pocket, Oleg Sterniola.
Sorry, I couldn't hear you.
It's trip number 6 from 2024 on page 2 of your annex.
Yes, I see it indeed. I mentioned the air ticket expenses, and the accommodation was covered by my wedding godfather that I mentioned already. And additionally, some expenses, some insignificant expenses, some approximate amount, because I couldn't find out precisely, because I paid in cash, so it was an approximate amount that I mentioned.
Okay. Then regarding the vacation in January 2024, spent in Brasov over a period of 3 days, that's trip number 11 in 2024. You declared that you did not incur accommodation and consumption expenses, as these were covered by your cousins. According to the statements signed by the cousins, vacation costs were usually paid individually by splitting the total amount among the participants. Can you explain this inconsistency and describe the activities carried out during that period?
That was about a visit to my relatives, my cousins in Brașov. The expenses that I mentioned, 500 and 500 lei for transportation and other expenses like green card. As you see, for the means of transport that I used, there were several people in it, so the expenses were covered partially by those persons, like gas, for instance, and green card. And additionally, when it comes to accommodation, the expenses were covered by my cousins who are living in that region.
So you did not incur accommodation costs?
No.
No.
And for consumption? Did you incur costs for consumption?
Everything related to consumption were mostly things, products that were brought from Moldova, and other consumption expenses were covered by my cousins.
Okay. And can you indicate for which amount of money you brought products from Moldova to Romania?
Cu siguranță nu.
Surely not. I'm not able to do that.
Then another trip where the same inconsistencies are noted in relation to the vacation in April 2024 spent in Brasov over a period of 4 days. That's trip number 7 in your annex. There you declared that you did not incur accommodation and consumption expenses as they were covered by your cousins, contrary to their declarations, indicating that the expenses were borne individually. Is this the same reasoning regarding the trip we just mentioned before? Did you stay with your cousins as well there?
Well, maybe lived there, maybe not. I don't remember exactly. But every time when it was about Brașov, that was covered by my cousins. When it comes to transportation expenses, that they were incurred by the people who were in the means of transport, partially by them. Sometimes more, they paid more than I did.
And then similarly for the vacation in August 2023, also spent in Brasov, 3 days. That's trip number 3 in 2023 in your annex. You indicated that you did not incur accommodation and consumption expenses, as these were also covered by your cousins. Also, they indicate that the expenses were shared among the participants. And for this trip, the same reasoning is valid as the 2 earlier trips?
Please, can I see on the screen the number of this trip, if possible, please?
Yeah, I'm going to show it. It's number 3, 2023. There it is.
Da, exact. Este vorba de...
Yes, exactly. Expenses were covered by Costin family, that is my cousins. The transportation expenses and insurance payment, that was covered by my family.
Okay. Then regarding the vacation in July 2023, lasting 4 days, and undertaken together with friends in the context of a hiking trip, and that's trip number 5 in 2023. You declared accommodation expenses of 300 Romanian lei and indicated that food products were purchased from the Republic of Moldova. At the same time, statements signed by the participants indicate that expenses were shared among them. So can you explain and specify the place of accommodation in relation to the declared amount and indicate the value of the expenses for the products purchased?
So you can see the place of accommodation is mentioned in the answers. Valea Doamnei, bed and breakfast in Nucșoara. When it comes to food expenses, as it was mentioned, they were brought from Moldova, and the accommodation and transportation expenses, they were split proportionally among the members of that group that we took the hike together with.
So the cost mentioned there is your part of the total?
Exact.
Exactly.
Thank you.
Totodată vreau să asigur că
At the same time, I want to make sure that is not a precise amount. It could be a 50 lei difference, for instance. I just don't have a receipt or something. That's why that is approximately how what I think it was.
That's clear. Then regarding the vacation in March 2022, spent in Iași over a period of 4 days, and that's trip number 5 in 2022 in your annex, you declared accommodation expenses of 380 euro and stated that meals were included in this cost. However, the booking confirmation indicates that only breakfast was included, which reasonably implies that additional expenses for lunch and dinner were incurred. Can you explain this inconsistency?
That was, well, not a visit, it was a trip to Romania, Iași, to help transport my mother-in-law, to take her to the airport, and we got accommodation for those 2 or 3 nights, if I'm not mistaken, and the expenses, transportation, green card, were covered by her as well, because it was needed for her to take her to the airport. When it comes to food, indeed, according to booking, it was breakfast only, but those consumption, not from breakfast, but during the days, they were incurred somewhere in the city, or products that we brought from home.
So you did not incur any costs for food or dinner during your time in Iași?
I cannot totally exclude that we consumed something, but the products that were used for lunch or dinner, that was food from home or some consumption in the city, not at the hotel, not as a lunch or dinner at the hotel.
No, because I suppose when you bring food from Moldova, you can't cook it in your hotel. So you need to have dinner somewhere in a restaurant, or?
There are some products that you can eat without cooking.
Regarding the vacation in 2024, spent at Pensiunea Lostrita over a period of 3 days, trip number 5 in 2024, you declared that you paid the amount of 1,500 lei for accommodation, while the remaining amount was allegedly covered by your friends, who submitted written statements to that effect. However, according to those same statements, vacation costs are normally shared among participants. In addition, the booking confirmation indicates a total accommodation costs of 759 euros, which is divided among 3 participants, would amount to approximately 253 euro per person. And that's equivalent to approximately 5,000 lei, a significantly higher amount than that declared. Furthermore, you indicate that meals were included in the accommodation costs, where the booking confirmation shows that only breakfast was included. Can you explain these inconsistencies?
De ce ține de această cazare și deplasare este
When it
vorba
comes
de
to
o
this trip,
drumeție în această perioadă.
it was a
Am
hiking.
indicat în punctul 5 referitor la
At item
acoperirea
5,
cheltuielilor
I
de transport și
mentioned
carte verde.
about the expenses for transportation and the green card. They were covered by Mr. Tarpan and Mr. Pietro Silvestro. And when it comes to accommodation, it was a hike with a larger group of people. A larger group of people that I don't know their names and surnames right now, because they joined this group over time. They are not close to me, and from the pictures that I have, it was a group of 8 or 9 people. So this booking was made by me because I was the one who organized the trip, and there on site those amounts were split in between or among 8-9 people, the accommodation expenses. What I have from that hiking is only a group picture with that group of 8-9 people. I can show it.
No, that's not necessary for me. But does it mean that this amount of 759 euros was for the whole group?
Sigur că da.
Yes, of course.
Okay, so not for you alone, but for the whole group.
Nu, dacă analizați această
If you
cazare,
analyze that accommodation place, it's not a luxury hotel
astfel de valoare de preț, e vorba
to
de
have such a
4
price.
sau 6 odăi, dacă
It
nu
is
greșesc,
a
nu
place with
mi-aduc
5-6 rooms, if I remember, but we were a group of 8-9 people. I don't remember exactly. So the group members reimbursed those amounts when we were there. That's why I mentioned approximately how much was my share. Also, I would like to mention that in the context of the hikes, the group members could cover even more than I incurred, because it was in a way well, a kind attitude from me to accept them into this group, and they were offering to cover more so than I was spending in reality.
So far for the questions around the vacations to my colleagues. Yeah, Mr. Gatkan.
Domnul Guzun,
Mr. Guzun, according to the information from the notice of hearing, from hearing notice, you saw that the Commission analyzed 50-60 trips of yours, and according to information from the SCM and from Chișinău Court, you used yearly leave for those vacations, plus some unpaid leave, between 10 to 20 days per year over the last 5 years. Could you please explain these unpaid leaves? Did they have any impact on your agenda? First of all, these leaves were taken with the consent of the management. No objection. Well, the management and justice seekers did not have any objection about delays of the cases, and 95% of these unpaid leave were taken in periods when I did not have any planned court hearings. I mean, I can't exclude that maybe there was 1 day or 2, but mostly those were days with no planned court hearing, maybe except for days when I had urgently to go to Romania to get the documentation, to get the documentation for children, or to transport my mother, or to visit my sister. Do you keep an archive of your court hearings? Do you have an agenda, an archive, a journal or an archive? Sorry, I don't understand your question. An archive of court hearings? No, I don't keep an archive. Not even in the case management system? Well, maybe in the system such information is about the date of court hearings and those periods. The current ones, sure, are there, but I don't know about the previous years. Can you confirm that during those days you did not have planned hearings? I confirm that to a large extent they were not, but I can't exclude that there were. Thank you. Now, microphone, please.
Well, Judge Guzun, then we move on to the next set of questions, and that's about the use of an apartment free of charge. According to your responses in the fifth round of questions, during the period from September 2019 to March 2022, while renovation works were being carried out in your home, you resided in an apartment made available to you free of charge by a third party. You stated that you do not know this person, do not recall the address of the property, and have not provided any information that will allow the identification of this individual. These circumstances are confirmed by E.N., Mr. E.N., who assisted you in identifying the apartment and who confirmed aspects in his responses submitted to the Commission. The question is if you can specify how it is possible for you and your family to reside for approximately 6 months in a property provided free of charge without knowing the identity of the person who granted you this benefit and without being able to indicate the address of the dwelling.
Exact.
Exactly. Well, when it comes to the address, as I mentioned, and I still sustain that, I don't remember the exact address of that real estate. I only know the region. When it comes to payment of rent, and during that time, I can explain the following. This apartment was offered to me through an acquaintance, fellow student from the faculty, and this colleague from there gave me the phone number of that person. They had a collegial relationship. I don't know the exact details. And after I got the telephone number, that contact I had with that lady, we found that this person used to work at the same employer that I did some time ago. So in a way or another, we knew of each other, and in those circumstances, she did not ask for any additional payments, but the payment for utilities for the apartment. For these reasons, I was not asked to pay rent, and I did not.
And how were the utility bills paid? Did you pay them in cash to this person? Or I remember you said your parents paid the utility bills?
I apologize, I did not say that my parents were not paying the bills. I was paying in cash, probably. This is the year 2019. That's more than 7 years ago. I don't remember all of the payments. If the Commission doesn't find any payments made by card, it means I paid in cash.
To the electricity and the gas company?
Exact.
Okay.
Yes, exactly.
Become the key of the apartment?
The lady transmitted it to me.
Or?
Exact.
Yes, exactly.
Exact.
Yes, I got in touch with her, we met. That's how we found that we used to have the same employer time ago, so she helped with that apartment. She gave me the keys, and for the period that I mentioned, I used that apartment, paying for the utilities as I reported in the question round. I covered the utilities from my family's money.
And after half a year, you also personally handed back the key to her?
I don't remember precisely the date when the keys were given back. Was it half a year later? Was it more? But I gave the keys to her, certainly. It was amid the COVID back in 2020. I can't remember very well exactly the date or the specific time when it happened.
And about this apartment, how many square meters was it? Was it furnished?
I can't tell how many square meters. It was not very big, a room or two maybe, 2 bedrooms, I think, if I'm not mistaken, and yes, it was furnished.
Poate cu excepția
Except for maybe just some appliances, some home appliances. I think those were brought by us.
And about the address of this apartment, I mean, you lived there for half a year. You went there, I suppose, every day from the apartment to your work and back. So how come you don't recall the address where you lived this half year?
Well, first of all, I'd like to say that in addition to the fact that I was living there, I was living at the house sometimes as well. So that's, well, there was renovation work in 2019 that were performed, but that was not for the entire house, just for a part of it. As regards the address, I really don't know what it was because that it was been quite a while. We did not have any documents with a person. In terms of bills, receipts, I don't remember that now, and out of the information that I have, I don't know the exact address. I know the place, but the number of the apartment, the floor, the exact address, I don't remember that. It's been 7 years.
Yeah, as I recalled, you came there every day. So, but anyway, and you lived there with your whole family. I mean, with your wife and children.
Da, exact.
Yes, correct.
Do my colleagues have questions about this topic? No? Okay. Then we move on to the next topic, Mr. Guzun. And that's about the unclear origin and source of income declared in 2015 in the income statement submitted to the SFS. Following a corroborated analysis of the income tax return submitted to the State Tax Service for the year 2014, and the asset declaration submitted upon appointment in 2015, significant discrepancies have been identified regarding the reporting of income. You probably know what I'm talking about this formula. And the questions are the following. Did you personally and voluntarily submit the income tax return for 2014?
Yes, I do not exclude that I filed it, but I don't have it in hard copy.
And as you know, in this tax return paper of the SFS, there's mentioned a declared income of 1.9 million lei and an adjusted value of 2.275 million lei. Can you explain how this came into this formula, these amounts?
First of all, I would like to draw the attention of the Commission to the fact that as for an analysis regarding that tax return, that analysis was shared with the Commission on Friday. Some additional details were provided. That's a thorough analysis of a situation that I believe has happened. There might one might claim there is an issue indeed from the State Tax Service as to how this was filled out, but there was one thing that I believe might have been the case, and I think the Commission will also understand that if in 2015 I reported such an amount, then this discussion regarding the differences in terms of expenses and income that the Commission has underscored, well, that wouldn't have happened. The 1,600,000, for instance, the sale of an asset occurred, and that amount is quite big, and therefore it is quite important an amount. So what I can say, though, this is a reiteration of what I've already said. In the state tax return that I have filed, I've mentioned other income that was supposed to be taxed by the State Tax Service. If you pay attention, in the document, it doesn't say what the source is for those assets. So, and a value like the one that I allegedly had in the opinion of the STS of about 2 million, back then there was about a bit more than 100,000 euros. And I, as you know, according to the information in the file, I did not own real estate. I did not have vehicles or any other assets that would have had that value. I, too, was really surprised by that piece of information that was shared with me by the State Tax Service. And therefore, I've even filed an application to acquire, to seek such information. I've sent this information to the Commission as well. I've shared it. In terms of any income in 2014, I mean, the State Tax Service did not provide such information to me, as in claiming that I, for instance, have sold some car or some assets, some real estate with a value of 1,600,000, if I'm not mistaken. So in the answers of the State Tax Service, I was not told about such assets, that I have allegedly owned that, and that I have allegedly sold that, and that I have allegedly earned some income in 2014. So I believe, out of what I know, out of the information that I try to seek and acquire, those declarations, those statements that the tax returns in the electronic format that the State Tax Service shared with you, they were filled out by hand manually. And I do not exclude it was a mistake of the State Tax Service that they've introduced that amount by mistake that made it look like I've owned some assets. The filling out of declarations of these tax returns, that procedure, I've detailed it in my explanations that I provided. As you know, back in those days, there were different institutions that were performing this filling out of the tax returns, and that is the content of an electronic tax return that does not contain my signature. My signature is not on it. So as far as, well, what I know is that I did not own such assets back in 2014 to be able to sell them in 2014 and to thus gain some proceeds out of the sale of assets that I didn't have. If I had such income, then it would have been to my best interest to report that and to state that I had that income, to have been able to cover other expenses that I would have had, given that it's quite a big amount, 1,600,000 lei. So this is my explanation.
Because I see a declaration of 24th of March 2015. There this amount is mentioned. And like 8 weeks later, in your declaration of income you sent to the State Tax Service, you don't mention it. So that's also
precisely
strange. So to summarize, you deny that you ever had the income of 1.9 million, or that you had assets for 2.275 million lei, and that regarding to your explanation in your letter from last Friday, the best reason for this amount mentioned in this tax formula is that they made a mistake at the tax service.
That's what I believe has happened. But I guess the competent bodies will be able to report as to how such a tax return was filled out electronically. Because the 2014 tax returns, they would be filled out by hand according to the law in Moldova. And then the State Tax Service and the bodies that they work together to introduce then the information to the database and to the electronic database. So they were also entering the information by hand or manually, so to speak, manually. So errors could have happened at any moment in time when they were filling out or introducing that information to the electronic system. So third parties could have introduced erroneously that information.
In your statement of 16 March, last Friday, you considered to file a complaint with the competent authorities for erroneously processing physically submitted documents. And I was thinking to myself when I read that, you're considering to do this, but why did you not already submit a complaint or ask the STS to adjust this information? Because now it's still in the system.
Deci am indicat că în rezervă acest drept.
I've stated that I had the right, and I've put down my reasons as to how I did not have those assets. And the tax return that you have is an electronic one that was not signed off by me. And I believed that, I thought that the Commission would have to analyze in good faith the contents of all of those statements, declarations, and altogether the whole information regarding the claimed assets that I allegedly had, but it doesn't say what assets those were. If the Commission believes that this is a violation or deviation, so to speak, by me, then I will exercise that right. I stated that I would exercise that right, and I have the time and the possibility to still do it. I was very thorough in my detailed explanation using indirect evidence from the real estate register, from the Public Services Agency. I show that I did not have such assets back in 2014. I did not have assets of that value back in 2014. And in 2014, that was about 100,000 euros. And if you look at the declarations of the returns, it's not even there. The State Tax Service did not even say what they were. And according to the law, the State Tax Service, when it comes to information like that, or to tax returns that are not filled out like that, shouldn't have been even introduced further in the system. And in my answer, I was very thorough. I provided a very thorough explanation, detailed, and I think it is quite a serious action.
That was not my question. My question was...
Da, n-am depus, că am spus că...
Yes, I did not file it, but I said that I would like to reserve that right to exercise it as the case may be.
But why wouldn't you do it right now? Because, in your opinion, it's wrong what's now stated in the system of the STS.
Deoarece sunt
because there are other circumstances that I've already detailed, circumstances that have to do with the way in which such tax returns or electronic tax returns are filled out, and the physical ones as well. And the State Tax Service has violated some actions, and I provided very thorough detailation of this fact, explanation of this fact in my written statement, so I count on the good faith of the Commission that thus it cannot be regarded by the Commission that I had allegedly owned some assets. It's not clear what those assets are. I did not report them back in 2015 when I filed my declaration upon employment. Now, Mr. Guzun, just for the sake of clarity, you have filled out a form on paper, and you then sent it to the staff of you've handed it over to the staff of the State Tax Service. Yes, that was the normal way to do it back then. Did you, well, in that form, did you put down this amount, 2,200,000, I mean, that transaction, all of that? In that transaction, the physical ones, I can't see what that was, but I think that what I put down was only the income sources that were supposed to be subject to taxation for 2014, those amounts. As for assets that I owned and sold in 2014, I did not put down any such information of having owned or sold any assets. Now, what about some transactions abroad? Did you engage in any transactions abroad? As far as I can remember, I don't remember having been engaged in any transactions. Like that, I may allow potentially through a representative, but even through a representative, if I allowed even for that, the source of income shouldn't have been reflected in that case as regards myself, but as regards the owner of the asset I would have represented. But I did not carry out any transactions in my own name or in the name of somebody else representing someone. As for your personal account, the taxpayer's account in the information system of the State Tax Service, did you look over the last years whether what this tax return said? Did you not notice that issue? I never came across it. I did not come across it. It became known to me now when the Commission brought it to my attention. Even when I've sought from the STS, from State Tax Service, even this STS did not provide any such information to me back then. And in my answers to the Commission, I've stated that that this is the income for 2012, 2013, 2014. The 1,600,000, that amount is not reflected in the answer that I got from the STS. I've only found out about it. It came known to me when the Commission brought it to my attention. But you can't remember of the tax inspector that you've raised the issue with, or maybe the city district? Well, esteemed member, back in 2015, if I was working in the Rîșcani district, it is possible that I've gone to the to the tax office that was based in the Rîșcani city district or Ciocana city district. It's either one of them. But now I don't remember with precision which one that was. But one thing is certain, that in 2014, for 2014, that is too big an amount. I mean, about 100,000 euros. I did not own assets of that value.
We move on to the questions regarding the inexplicable wealth. Following a detailed analysis of your financial situation, the Commission has preliminarily established the existence of inexplicable wealth for the years 2019, 2021, 2022, 2023, and 2024. In total, as I said at the beginning, 928,000 lei. And as you know, there's a threshold of 234,000 lei. Regarding the year 2019, according to the information available to the Commission, the inexplicable wealth is almost 69,000 lei. And it's determined by the cumulative level of annual household consumption expenses, loan repayments, as well as expenses incurred for vacation and for children's attendance at preschool educational institutions. So the question is regarding the source of funds you used, or your household used, to cover the negative balance. And of course, you also already wrote last Friday in your reaction that this inexplicable wealth is there because of we, as a Commission, did not take the full donations of your mother-in-law in account for this year, and also the donation of your mother. That's right, eh?
Yes, I have explained that. I have detailed that in the explanation. And today at this hearing, I can reiterate that. With regards to 2019, I would like to first of all mention that as regards my mother, the donation in 2019, as regards that, I would like to say that the Commission, in my opinion, has not taken into account this donation from my mother, and it claims what it is. But I provided the statements of my mother as well, and there was information regarding the year of the death of my grandmother. So there's an amount donated when she passed away. There's a death certificate that was submitted, and to the Commission I've presented that certificate from the company that was managing that farmland that used to be owned by my grandmother, and they were processing those farmlands. And they were growing their crops, grains, sunflower, corn, and some other grains. So, in my opinion, so a woman who is 88 years old, with a quantity as big as that she was getting every year, about 1 ton, a bit more than 1 ton of grains a year. And she was living alone in the countryside. It was not realistic to acquire such income and to pass that on and over to her children. How much bread can you bake with 600 kilograms of wheat? How much oil can you produce and use at 88 years old? And how much corn are you going to use for about 10 chickens in one's household? So as to believe that those amounts were not realistic. I've indeed put down that those funds were not being kept on the account of my grandmother. She did not have an account. The pension would be given to her from the post office. She would have it from there. She was not managing her funds using accounts that she could have otherwise had, meaning that the money was being kept in cash at home. The money was handed over by her to my mother, and my mother in 2019, given the renovation work that we had, that money was handed over to me. That is an amount like an ordinary payment in this regard of a value like that. I did not put it down for other periods of time. That amount was put down for that year. It was unique in kind for 2019 when my grandmother passed away. And therefore, this is my position as regards the 3,000 euros amount. That amount was handed over, given by my grandmother, a part of that accumulated by my mother, again from the sale of goods that were sold by my grandmother, the carpets and other assets that she owned in her household. As regards the rejection of amounts, speaking of donations from the mother-in-law, in that regard, there is a matter that has in fact to do with all of the years where the Commission has found some negative balances or insufficiency of funds for my family. In this regard, I would like to mention the following: that the money that was established as donation every year by me, that is money handed over by my mother-in-law every year by wire transfer or by cash. The Commission established that those amounts as cash cannot be accepted, considering the fact that they are not supported by anything, and therefore that there was no capacity for such amounts to have been given over to me. But in the materials that I provided, and considering the statements made by my mother-in-law in the hearing, she said that she's been in Spain since 2002. According to the information provided to the Commission, the amounts that she has acquired officially are above 250,000 euros. Therefore, if we take precisely the period of time that is subject to my evaluation, 200,000 euros, those amounts officially were the ones received by my mother-in-law in Spain. What is more, the Commission is not taking into account the fact that those amounts that she was receiving, well, they represented just a part of her income, because she was also earning informal income for the hours that she was working after the usual working hours. So I've told the Commission, I've also provided evidence to the Commission that in her bank statement you could see names of individuals, natural persons, and some part of the money they would deposit to her account, they would transfer that to her account, which is confirmation of the fact that she was also working informally after her official working hours. There was very thorough details. There were thorough details as to the costs of per hour work. I mean, how much that would cost per hour. And she has also reported that she was working unofficially after her official working hours. And she had the financial capacity to, in fact, provide us those donations. What is more, with regards to this matter, there is already a practice that is well established, including by decisions of the Vetting Commission of the Supreme Court of Justice. There is the one that is of number 37, the decision number 37, and then another decision number 41 of June the 9th, the decision of Supreme Court of Justice of the 26th of June. And over there, it is established by both the Commission and the High Court that indeed, this is a reality typical of Moldova, that Moldovans who work abroad have also worked informally, and that they've also had informal income earned, and that therefore those amounts were accepted by the Commission and by the Supreme Court of Justice. As you can see, the differences are very small, thinking of the amounts that were transferred now. Well, in different periods of time, they were transferred. Different amounts in different periods of time, in different ways, depending on the needs, depending on, indeed, the family needs. And I provided details as to the amounts that she has earned, the amounts that were transferred to my family. Therefore, as regards The financial capacity of my mother-in-law, it is clear that she had the financial capacity, looking at the materials in the file, she had the financial capacity to provide those amounts to us in cash and by transfer. What is more, it is not clear what the position of the Commission is with regards to the calculation supporting these, the lifestyle of my mother-in-law is where it applied. A method that I believe that was identical to hers, to myself, meaning statistics from NBS. I imagine there is a National Bureau of Statistics of Spain that have some information as per or as to consumer expenditure in Spain, perhaps for a Spanish national. There were some links that were shared by the Commission, but they are in a language other than the one that I know. That information was in Spanish, and I believe that that was supposed to be some statistics that was supposed to reflect consumer expenditure in Spain. Regardless, even if the Commission applies that calculation formula to figure out her lifestyle in Spain by using those specific statistics from Spain, still the Commission did not apply the methodology fully as set out in Annex 1 to the regulation on the operation of the Commission, as it did not take into account any balances, any cash balance of her, the cash that she had for the time, throughout the time that she too was subject to a verification according to that method applied by the Commission as set out in the notice. Meaning that the Commission strictly focused in a linear fashion on 4 years without having established what the balances, the cash balances were for her, that was she was supposed to have at the time of the evaluation according to the materials of the Commission. Annex 1 to the regulation establishes that there is an obligation of the Commission that when it establishes some flows of funds, and when it establishes inexplicable wealth, it says that it has to establish the balances as well, the opening balances just when the verification begins. But I believe this was not performed by the Commission. And therefore, we cannot claim this was a correct, accurate analysis of the funds owned by my mother-in-law while in Spain.
Going back to the donation of your mother, you were talking about your grandmother. How many children did your grandmother have?
2.
And she also gave some part of her inheritance to the other? So not to your mother, but to the other kid?
As regards the inheritance, in the information that I've shared with the Commission, there are the wills and the inheritance as per the laws of the inheritance regarding real estate. That part, the inherited real estate, that was accepted by me and then sold. Same is true for my cousin, and information with regards to that was already provided to the Commission regarding real estate. As for the amount at issue, the one that was transferred by grandmother to my mother, that was given upon acceptance of her sister. Given that my mother is living alone, she was living in an apartment and she had greater needs than her sister. What is more, her sister lives in a detached private house. She has some crops, some agricultural crops, and she is able to cover her living needs. And for those reasons, the money was given only to my mother, but her sister agreed to that. I mean, she agreed to that, but they decided on it together. She said, Luba, I allow you to have this money because I don't need this money. And thus, my grandmother gave the money to my mother. And that is the explanation. The inheritance now as regards the real estate, those assets, that inheritance was regarded the cousins through a will and on the basis of acceptance by the cousins of how the assets were supposed to be distributed after our grandmother passed away.
So your mother got the money of her mother because she needed it more, but then she gave it to you.
Exact. Nu că era
Well, it wasn't that she needed more, it was my grandmother's decision. You live in a flat, you have more need. Because the other one had a husband living on a house of her own, having a household with animals, poultry. So she gave the money to my mother because my mother's sister was well, more advantaged in terms of financial ability and her agricultural harvest, crops, and so on. Well, my mother was living in a flat. Her husband passed away by that time, so she was in a worse position than her sister. But later on, the savings, maybe this was not the only amount, but at least I'm saying that from the perspective of the amounts that my mother gave to me.
Okay. Questions for 2019? No? Then we move on to 2021.
Eu îmi cer scuză.
I apologize. I am not done with 2019, if I may.
Da. Am vrut un alt aspect să-l relatez de
I wanted to talk about another aspect, that is transportation expenses for 2019. These expenses are applicable for the entire period when I used the Honda CR-V car that was on using a gas installation. Those expenses are for 2019, 21, 24, 24 included. But when it comes to Honda CR-V, those are years 2019, 2021, and so on until 2022, when I purchased another means of transport. Esteemed Commission members, I wanted to point out an important thing. Well, initially, when I provided information about the way that this vehicle was traveling, what fuel it used, the Commission initially did not mention those expenses because it couldn't analyze the consumption of liquefied gas. That was excluded from the calculations, but later I found in the Commission's notice that this calculation was there, and in this regard, I have some comments for the Commission and some doubts about the way those expenses were calculated. So, based on the notification provided to the Commission, I found that the Commission was using, I would say, a source, an official source for establishing my fuel consumption expenses, specifically liquefied gas. Using the link that the Commission referred to, I found that it was a website, a Turkish blog, where someone was presenting consumption of liquefied gas for a means of transport. Well, the Commission, the entire process mentioned that things need to be confirmed by documents that have official evidentiary value, that are pertinent. But on the other hand, for the fuel consumption expenses, the Commission accepts an unofficial source of a private party that is telling how much how much gas would a vehicle consume compared to petrol. So there's a natural question of that. Why Turkey? Why not another country? Why the maximum value of 20 and not 10, which the Commission has established? So Why not an official source of a manufacturer of gas installations that would show precisely what the gas consumption is for a vehicle of this make and model? An official source. The Commission did not do anything about it. Therefore, I believe that this value needs to be adjusted by the Commission because this value is not correctly established.
So what should the value be then?
The Commission should have established it by finding a manufacturer of gas installations who could give an answer to the Commission about the gas consumption for such a vehicle. We cannot talk about a value that is mentioned in a Turkish vlog, who is a private party that is renting cars, because some additional expenses are imputed to me and I have to accept them being part of the Commission's calculation.
But also in the hearing notice, we have written it's well known that when you use LPG, you use 10 to 20% more for a kilometer or 100 kilometer than when you use benzene. That's well known. I mean, if you ask at Google, you get like 100 pages where it's stated that this is the fact. So that's why I ask you, what's wrong with the number we've used? Because if it's Turkish or American or Moldovan or Romanian, it's probably everywhere the same number.
Well, we can presume, but the Commission did not do that. Furthermore, in order to establish a value with transportation expenses, official sources should have been used about the gas installation and how much it consumes and the percentage. So if the Commission, even if it carried out an analysis, it should have been using official data from manufacturers, not from a private company that is renting cars in Turkey.
This is what you wanted to add for the transportation costs in 2019?
Da, exact.
Okay.
Yes. Yes, because it shows calculation based on that method. Do you have a version of your own about that consumption? I cannot make any statements like that. I'm not a professional in this field. Tell us, please, your travels in Europe. You were using liquefied gas for your car as well. From what I remember, I only used once Honda CR-V to travel to Europe, and I used liquefied gas in Europe, yes. Can you tell us in what country? I apologize, but it has been long since, I don't remember. And you don't know the actual consumption? Of course not.
Okay, then we move on to 2021. According to the information available to the Commission, in 2021 the financial outflows of your household appear to exceed the financial inflows by at least 403,983 Moldovan lei. And also here is the same story for the donations of your mother-in-law we just discussed. And a main topic here is the loan of Mr. Karaus, which we wrote about in the hearing notice. Do you want something to add to this year, 2021? Of course, you did it already in your written statement last Friday, but do you want something to add here? And it here also,
Da, evident.
The transportation point is the same as in 2019, I suppose.
2021 eu mijlocul transport Honda l-am deținut încă jumătate.
Yes, in 2021 I still had the Honda for half a year, if I'm not mistaken. When it comes to the informal income of a mother that was not accepted, well, it's not known if it's informal or not. The amounts that were sent in cash, they could have been formal revenue from the work that she did officially. Regarding the loan offered by my cousin, I would like to comment on this very important aspect, because despite the fact that I described in details and I provided records, evidence, statements of my cousin that he had such amounts available, the Commission is again using calculation methods that are advantages only to determine negative amounts and not to accept amounts that entered my account in 2021 for that apartment. Namely, I would like to talk about the fact that if you analyze calculation made by the Commission about this third party, my cousin, the year that the Commission calculated was year 2021, the year that when the funds were offered, and the year 2020. But going back to this analysis that the Commission should have carried out if it would be correct and in line with Annex 1 to the Regulation on Organization and Functioning of the Commission. So, in what the Commission mentions in the notice, the analysis of my cousin's financial resources in 2019, in the Commission's opinion, his balance was zero. How was that zero determined? Or that cash balance? Because Annex number 1 states clearly that in order to determine the financial capacity of a person, several aspects need to be taken into account. First of all, the balances, cash savings, both in accounts and cash. While my cousin reported repeatedly, and I also did, that the money he gave me were the results of savings made not only in 2021 or 2020. It was a much longer period of making these savings. While the Commission believes that in 2021 he had a negative balance, and in 2020 he had it negative as well. Therefore, he had no financial capacity to transmit this money without commenting on what was his cash balance in 2020. Based on the information that I provided to the Commission and based on what my cousin stated, he had enough financial resources to loan me that amount, to lend me that amount.
Thank you. Any other questions about 2021? Can we move forward to 2022, Mr. Guzun? There, the Commission has found an inexplicable wealth of 170,000, a little bit more than 170,000 lei. That is results from the level of annual household consumption expenses, loan repayments, payments made for the apartment, expenses paid to private medical centers, as well as repair works for the painting of the house. And that's also a point of discussion you mentioned in your writing last Friday. That you state that the statement of your mother on this point, when she was as a witness here, was wrong, and that she made a mistake because the house was painted in 2024. Is that right?
Exact.
Yes.
Would you like to add something to this?
I provided records with pertinent evidence that the house was painted in 2024. Those are my neighbors' statements, a picture that I found from that period, and from what I know, information was requested from the handyman who did that, and he reported that the works were carried out in 2024, not in 2022. When it comes to repairs, and the amount that the Commission holds as expenses cannot be accepted in this situation as an expense for year 2022. Mother-in-law made a mistake indeed. In 2022, we did not paint the house. As well, maybe she was overwhelmed, stressed. She was transferring amounts, bigger and smaller, for over a 20 years period. She did not remember exactly that the amount was used for repairs or for painting and so on.
Questions for 2022?
În afară de reparația ce se
Besides the painting of the house, were there any other works, gate, fence? We did that later on in 2025, after the spring. Based on the handyman's statements, it was not clear. Did they buy the construction materials or you incurred expenses? Well, I was giving the money to that person who was responsible. Maybe I purchased some materials, but in 2024 we painted the house, and the money I was giving to that worker, maybe something not significant was purchased by me. Otherwise, it was that worker dealing with this. So what about some bank transactions paid by card or getting invoices for purchasing certain good? You don't have it? No, thank you. Microphone, please.
Then 2023. The other commission found an inexplicable wealth of a little bit more than 190,000 lei. Are there comments you want to make on this year, Mr. Guzun?
Regarding 2023, the Commission again does not accept the cash that was given to me by my mother. I expressed my position in detail about her financial capacity to give me that money.
Okay, then we have the inexplicable wealth in 2024. The other commission found an inexplicable wealth of a little bit more than 93,000 lei. And also for this year counts that not the full donations of your mother-in-law were taken into account. And as you also mentioned in your writing from last Friday, in the hearing notice, it's accounted for 40,000 work repairs for this year. And last Friday you wrote that it should be 20,000 in 2024 and 20,000 in 2025. That's right, huh?
I apologize. I mentioned that in 2024 I painted the house and I incurred the expenses for painting the house in an amount of, well, the material together with the work, they cost around 40,000. The payments that were made in 2024 were only for materials, and after the worker finished painting the fence and so on, everything else was paid in 2025.
So around 20,000 for materials and around 20,000 for the other work.
Exact.
Exactly.
further questions about inexplicable wealth, my colleagues? No? No. Good, then we move on to the potential ethical breaches, Mr. Guzun.
Да.
And this is the topic about the classification of a claim for exclusion of an associate and redistribution of shares as a non-pecuniary. As we wrote in our hearing notice in January 2026, the Commission received a petition from an individual, RB, concerning 2 decisions issued by you in cases involving a company and its former administrator. And the questions we have relate to the second case. Because in that case, a person, ET, filed 7 similar claims seeking the exclusion of RB from the company's associates and the redistribution of 40% share in the company's capital in favor of the company. Before the case was assigned to you, 6 similar claims had already been filed by the same claimant. Initially, the claim also included material damages of 22 million lei, which resulted in a significantly higher state fee, and in subsequent claims, the damages component was removed. And despite this, the courts adopted different approaches. Some classified the claims as pecuniary and set higher state fees, while others treated them as non-pecuniary. In the case assigned to you, you classified the claim as non-pecuniary and set the state fee at 250 lei. The claimant paid this fee and the case was accepted for examination. Your ruling classifying the claim as non-pecuniary does not contain any reasoning. And according to your responses to the 5th round of questions, you stated that you relied on the law on state duty without providing further details. So then our first question is, how common is it in your practice for claimants to file multiple identical claims? And how should a court address such situations?
Well, when it comes to identical claims, I did not know about them. I found out on the date when, at the first meeting, I got a recusal declaration by the defendant. In the context of that declaration of recusal by the defendant in the court hearing about my recusal, I found out that such claims have been filed with court with other colleagues, and the recusal declaration was substantiated on the fact that I examined the case. The recusal declaration was examined, it was rejected, and after I received the case from the colleagues who looked into the recusal declaration, in the context of a declaration of the defendant's representative that decision to accept cast doubt, given that others did not accept it before. I abstained from examining that claim in order to avoid claims that I had any interest, because previously it was filed with someone else and it was not accepted, and I accepted. So because of that, I filed a declaration of abstaining from this case. It was examined by my colleagues, it was rejected, and it was sent back to court, which means to my panel. Why did I qualify it as non-pecuniary? I mentioned the legal provisions that excluding a shareholder is a non-pecuniary matter, and given that there was also a request for redistribution of a stock, this had to be covered in the context of Civil Procedure Code. When the case was being prepared, we needed to establish what was the share to be redistributed, what's the value of it, of the shares, and on the date of decision being issued to make sure that it is real value. And there was a legal mechanism that if there is any objection from parties to the case about the acceptance and qualifying that claim as pecuniary or non-pecuniary, it had to be solved additionally by means of a conclusion or determination. But representative of the defendant came to the first hearing with the declaration of recusal. If that aspect was raised by the parties at the first preparatory meeting, of course it would have finished, and if there would be an additional request to pay the additional state court fee, because that is allowed by the procedural rules to remove some, but unfortunately we haven't started to examine that case while there was already filed a recusal declaration, and we started to look into that.
But you said you didn't know there were already 6 cases, same cases filed before, huh? But my question is, how common is it that citizens file the same claims for like 6, 7 times? Does it happen more often?
Well, you should ask management about that, because they may be doing some analysis in this regard.
But you don't have any knowledge of this practice?
Well, at least in the court where I was working when I issued the determination, I did not know about such practice. Well, I can't exclude that they happened before, they happen in the future. I really don't know. In the court where I worked, I found out about those similar claims only on the date that the recusal declaration was filed. As soon as it was declared, I wanted to abstain and not to exclude. It's because I know that the judge receives claims and not redistributing. The redistribution can be done by the secretariat under the court leadership.
So then you also don't know why the claimant, when the case came to you, pursued her claim?
Sorry, could you please repeat that?
Well, the claimant did not proceed with payment, even when a similar claim had previously been classified as non-pecuniary. But she did pursue her claim in your case. And the question is, do you have any idea why she pursued the claim in your case?
What do you mean that she pursued with that claim?
Well, she filed claims, identical claims, 6 times before.
Possibly, from what you say according to the materials.
Then nothing happened. She didn't pay the state fee, or she didn't follow up in the procedure, so that ended. And then the 7th time, the claim was coming to you, and you handled it. And the question is, why would she, when the claim came to you, pursue this claim? Meaning bringing it further, paying state fee and...
How can I answer on behalf of the claimant why she pursued with it? We have more than 500-600 claimants. We are not asking them why you file claims. They don't know. Of course I don't know. This question should have been asked to her.
Yeah, I think she didn't give an answer on it. One last question about this topic, about your ruling. This didn't contain a reasoning regarding the classification of the claim. Is that correct?
The ruling is argued, well, the way it is by the court, and we've qualified it through the lens of the object of the action that was claimed at that time. So, in that ruling, it's not a very detailed description. There isn't a very detailed description of every aspect of the matter. The court, if it allows it as a non-pecuniary, then it receives it. It imposes a state court fee as regarded by the court at that time, and the reasoning is that in the ruling not to allow that, we've established that it's non-pecuniary lawsuit in the opinion of the court at that time, and the applicant, the claimant, further on addressed this matter of the state court fee that was established as a non-pecuniary action, the court fee, and that was all. If in the first hearing in the court and the preparation stage, if the party would have claimed that additionally they would pay the state court fee, given that that was a pecuniary action as regards a particular claim, then that would have been cleared very easily. That would have been addressed through an analysis, and we would have looked into the opinion of the other parties in the lawsuit, and if the court would have reached a different conclusion, they would have required the claimant to pay the difference in terms of this state fee. What is more, during the examination of the case, the Civil Procedure Code allows that if the court establishes that the value of the action of the lawsuit is a different one, or if there is a pecuniary action and it has to be qualified as such, then that difference in terms of the tax fee is to be collected at the same time with the release of the decision of the court.
So these judgments classifying pecuniary or non-pecuniary are more or less standard judgments. Is that right?
Well, as for a ruling in these regards, it's about 6-7 rulings like this a day. A lot of cases are coming along. So when there is some objection as to the participants in proceedings, and the court has to look in this particular matter in a thorough way, then analysis is carried out and a particular solution then is taken depending on the positions of the parties to the proceedings. And indeed, in a week there are about 50, 100 rulings of that nature, depending on what the case may be or require. And a lawsuit, looking into a lawsuit for a court, I mean, that there's a very little time for a court to address that. I mean, it's about 5 days. And therefore, the court is adopting such rulings upon the first examination, so that later on, if some new circumstances emerge or if some uncertainties appear for the participants, for the court, if there's some objections as to the amount of the state court fee, then this is addressed during the preparatory stage, when they were preparing for the court hearings, when the objections are raised by the participants in the proceedings. In the meeting that we had regarding that case, at the first meeting, there was an application for recusal, or a request for recusal filed.
Okay, thank you. Other questions about this topic?
This case, is it you still who is handling it? Yes. At this moment in time, it is. And what stage of examination is it at? As I've mentioned initially, there was a recusal application. It was redistributed. That was rejected. The case came back. At the next meeting, there was my declaration, my statement to abstain, given the statements of the representative of the defendant, stating that that particular lawsuit, that action has gone through a number of stages, given that several times it was filed, and to exclude any doubts as to me that I have some interest there. That's why I filed an application of self-recusal that was examined and rejected. And then the case came back, and then the date of the next meeting is, I think, in May. So you did not start the actual examination of the merits. Not even the preparation was finished for that. Vom vorbi despre
the Hyundai Santa Fe free of charge. During July-August 2021, you used free of charge a Hyundai Santa Fe for a round-trip vacation to Spain. And initially, you stated that the person who provided the vehicle was an acquaintance without offering further details. And in the fifth round of questions, at the Commission's request, you provided his contact details. And in response to the Commission's inquiry, VC stated that you have been close friends since your university studies. And he mentioned that no contract was concluded due to your friendly relationship. And for the same reason, no fee was requested. Additionally, according to official information, VC is involved in several criminal cases. And the first question is, how do you explain the discrepancy between your description of VC as an acquaintance and his statement that you have been close friends since university? Can you explain this?
Well, I will support my position that I've communicated to the Commission. Indeed, as far as this person is concerned, well, we've been together in university, but I can't remember all the details, but I've known him since back then. Afterwards, with this person, I've interacted in that way, meaning I used that car, and that person had we had some common acquaintances. He also knew some people that I knew, so that's how I also knew him. In his view, if he thought that I was his friend, well, I don't know what is his definition of a friend. I've never been to his birthday parties, for instance, and I'd never been to any of other events organized by him. I've never been on holiday with him. I've never had any other connection but that particular situation regarding the car.
And did you see him? Did you see him often, or did you see him before 2021? Did you meet during the time between university and 2021?
No.
No.
So how did you come in contact with him? And how did you come to the idea that he could lend you a car? How did it happen?
Well, I've stated that in that time, I was also thinking of purchasing a car, given that the Honda CR-V was quite old, and I was looking for a vehicle that would have allowed me to travel with greater ease to Spain to my mother-in-law. So I asked one of my acquaintances about whether they knew anyone who could give me that car, given that that person had the parking with cars on sale. So I was told that there is a car there that could be used and that I could be using without additional costs other than the fuel that I paid for. So that's what it was actually. That's what actually happened without a takeover handover document, without having registered this in terms of, for instance, how many kilometers were there, the mileage that is when it was given to me, without having imposed any fees whatsoever. So that was that one situation where I used a car that belonged to that person.
Isn't it quite uncommon to lend a car from a person you know not very well for like 3 months and drive to it with the car to Spain and back and use it? You don't have to pay anything, or it's not a thing what happens to a lot of people, I think, that you go to a garage and say, hey, you can use this car for 3 months, you can go to Spain, you don't have to pay anything.
Well, that particular car was not for 3 months, but for that particular trip. And it is something normal, a normalcy in our society between people who know each other. If that is recommended by another person that is like an acquaintance, that is trusted acquaintance. And back in that day, I was looking for a car, given that my older car was already indeed quite old, so I was on the lookout for something. So that was sort of the reasoning as to why I took it. I was going to just use it for that one trip to Spain.
Have you ever received any other benefits or services free of charge from Mr. VC?
Not as far as I can remember, nothing else, nothing but that.
Did you provide at any moment, directly or indirectly, any advantage or service to Mr. VC in return?
No.
No.
And as you have read in the hearing notice, that at the time of using of the vehicle, Mr. VC was involved in criminal proceedings. Were you aware of this?
No.
I was not aware. It became known to me from the information shared with me by the Commission.
Okay. And if it was aware to you at that moment, would you have lent a car of him? It's an if question, but...
Perhaps not. Perhaps yes. Maybe yes, maybe no. Out of what I found out from the Commission, there are criminal cases. I'm not sure whether there is a sentence or not. Was he convicted or not? I think not, from what I gather.
Well, no further questions about this topic, you, Mr. Katkan?
So, Mr. Guzun, you told us about this as this was reflected as some help from that person. If that person had nothing to get out of it, no advantage whatsoever to gain out of it, out of helping you out by giving you that car free of charge, well, I did not give him anything in exchange for using that car. Not to him as a manager of that particular parking facility. I did not give anything to, well, him as or to anyone as the owner of the car. He was not the owner of the car. But in the future, do we expect him extending any requests to you? What requests? Well, from you, some advice, some support, some consultation from you to him. About what? About anything. Well, anything. It cannot be anything. It can be a glass of water. That's one thing. When it's something else. Well, did you promise him anything in exchange? No, I promised nothing in exchange to no one. And all of the expenses regarding the maintenance of that car over that time, that was all covered by you? Yes. And I am just speaking of the travel to Spain, the trip to Spain and back. And when the car was given back, did you have any agreement, as in take over, hand over, some sort of a document? Well, I've already told the Commission multiple times that there was no document on handover, takeover, not when I got the car, not when I gave it back. Understood, thank you.
Okay, then the last topic, Mr. Guzun, about the potential conflict of interest. We already spoke about it on the last hearing. But after the hearing of 2 February 2026, the Commission received additional information from Premier Energy, your former employer, before you became a judge. And they confirmed that your wife was employed by the company between 2002 and December 2020 in positions outside the legal department. And from April 2013 to August 2020, she was on childcare leave and she resigned in December 2020. The company also confirmed that you worked on the company from November 2002 to April 2015, initially as a trainee, then as a legal advisor, and later as a head of judicial litigation service. And that was from March 2009 till April 2015. My first question would be, can you confirm if this information from your former employer is right?
Yes, I can confirm that in 2013 to 2020, she was on child care leave, having been employed with that company. And yes, she was an employee of that company.
And then one last question, and that's about your job as head of the Judicial Litigation Service. What were exact your tasks and responsibilities as head of the Judicial Litigation Service? Can you explain this to us?
Well, out of what I can remember, because I might not remember all the details of that has occurred 11 years ago, but there was a representation in court, representing the company in court, legal assistance for the company to the different departments of the company, so within the company providing that legal assistance and supervision of representatives and analyzing the work of the subordinate colleagues.
So did you represent cases yourself for your employer before the courts, or did your subordinates represent those cases in court?
I too, and my colleagues as well.
And it was your responsibility that the representation of these cases before the court would go in an all right manner, and that it would be in time, and that people show up at the court hearings.
So as regards my subordinate colleagues, I'd like to mention that the head of department would be the one doing the analysis of their work. However, when there was some statistical analysis of some information, it was also always my responsibility to analyze the statistics of all my colleagues. But to a great extent, it was the director who was checking their work in terms of their representation in court, the documentation submitted to court, the strategies of defense in court in the cases.
What was your exact task then in this whole story?
To represent the interests of the company in court and to provide assistance to the different departments of the company what I was working in.
That was my last question. Do my colleagues have additional questions? No? No? Okay. Well, Judge Guzun, as he asked all our questions, would you like to make a brief statement before we conclude the hearing?
Yes, if I may, I would. As you know, today at 9 o'clock, I've sent a piece of information to the Commission. So what was that issue about? Throughout the examination, as I was looking into the notice, as I was examining it, I've noticed some information generated by AI in the way that questions were worded and in the way that some doubts were worded by the Commission. In that regard, I've looked into the current rules in force as regards the verification, the evaluation of subjects of the evaluation. As regards this matter, I haven't found any provisions to cover this situation. And on this note, I have, as far as I'm concerned, I have a lot of doubts as to the way in which the facts were established as in terms of the use of AI for my evaluation. And to be specific, I've identified that AI was used without seeing in the materials of the Commission, without seeing what the questions were, how were the questions worded, how specifically how the queries were worded for the AI to establish some facts that were further on used by the Commission in order to to identify and to establish what the financial situation of my family was. Speaking of expenses, for expenses, the Commission would use artificial intelligence. But in terms of income of my household, artificial intelligence was not being used to obtain some sort of information, some source to figure it out. The Commission would not apply AI for that part of the matter. And this is my first claim that I would like to raise in today's hearing. I would also like to underscore now for the Commission some aspects regarding how I was treated in comparison to other colleagues of mine who have passed the vetting, who have passed this evaluation as far as the financial matters and ethical matters are concerned, meaning that the same treatment should be applied. The Commission that is now in front of me should apply the same treatment, and the Commission or other panels of the Commission, they've applied some particular treatments to financial sources, to funds coming from parents, from relatives, family. Those sources, I mean the funds, when I say this, I mean the funds obtained from informal labor, and they were accepted as trustworthy, they were used as mitigating factors by the Commission, and they were accepted by the Commission, and they were regarded as income of the subject of the evaluation. So these are the additional matters that I wanted to mention. Microphone, please. Thank you.
Thank you, Mr. Guzun. Well, regarding to your your first remark about the use of AI, I can already maybe explain a little bit how we use it. As you mentioned, and read in the hearing notice, ChatGPT is used. We don't deny this. It's in the report, so it's no use of denying it. But we use it as a search engine. So the same like Google, Yahoo, or any other search engine. But we don't use it to find inexplicable wealth or ethical breaches. And we don't use it for writing the contents of the report or making conclusions based on financial figures we find of your bank accounts. So it's only used as a search engine, just like Google or any other search engine, but not for developing arguments or reasons in the report itself. So just to have this clear for you. Well, having said this, Mr. Guzun, we have come to the end of today's additional hearing. And I thank you, Mr. Guzun, for your submissions and answers to the questions. And after the hearing, the panel will approve on the evaluation report stating its conclusion, whether you meet the criteria for ethical and financial integrity in the law number 252/2023. And the panel will strive to complete its evaluation report and announce its conclusion as soon as possible. This hearing is now closed. Thank you for your attendance, Mr. Guzun, and I wish you a good trip back.
Mulțumesc.
Okay.
La revedere. Mulțumim.